Peter, good afternoon. Nice to see you again. It's been a while, but not such a long while. And I believe we've got something hot off the press to discuss today, apart from a few other things, perhaps.
Yeah, exactly. Well,
yeah.
The judgment in the Spur case came out a couple of days ago, and that's made a lot of news, Trevor. So I think we can have a chat about that.
I mean, today is the 19th of October, and the judgment was handed down on the 15th of October. 15. And I read it for the first time this morning. So, so it feels hot off the press to me.
It's not often a tax judgment makes news, and this has really made news. There've been a lot of articles on business days and other, outlets, and it's also been in business news a lot. And I think maybe we can start off just with the facts and then go from there. So, as you say, Trevor, that's our job. We describe the facts, we sort of understand the law, and we apply the law to the facts. So let's start in the right place.
I think I can say this, whereas perhaps you can't. I think you have a lot more experience at the coalface in this field than I do. So you've probably seen a lot of similar arrangements, or perhaps variations on a theme. So you can comment more intelligently, perhaps, than I can.
Yeah, thanks, Chair. And maybe just to kick off with the facts. So Spur set up a share incentive trust in 2004. And Spur Holdco, which is the listed company, was appointed the capital and income beneficiary of the trust. And we're going to come back to that because that's quite fundamental. Then Spur, the operating company, made a contribution to the trust in the amount of 48 million rand. And the trust took the 48 million rand and subscribed for preference shares in a new company. It's called it Newco. Newco took the money and bought listed shares in Spur Holdco. And last step is that Newco then issued ordinary shares to employees of Spur, this being a share incentive vehicle. So the employees subscribed for the ordinary shares at a nominal value, and they got potential upside in the value of the Spur Holdco shares over a 5-year period from 2004 to 2009. And those shares that they held were restricted equity instruments in terms of Section 8C. They had some lockup provisions, so they couldn't freely dispose of them. So they were incentivized. They basically got free shares that could increase in value. And roll forward to 2009. In 2009, Newco redeemed the preference shares that it had issued to the share incentive trust, and including a dividend portion, being preference shares, they carried a coupon rate on the preference shares. So the redemption price, which was the capital plus the accrued dividends, was settled by Newco delivering Spur Holdco listed shares up to the trust. And because the share price had increased, Newco still had some shares left over in Spur Holdco, and it sold those shares, took the money and made distributions to the beneficiaries who were the shareholders in Newco of the ordinary shares. So those were the employees of Spur, and so they got the upside that they were hoping for. And that was the end of the share scheme. And along the way, Spur, remember that contribution it made to the trust, the 48 million rand, it deducted that and said that that was in production of its income. And the reason why is there's the old case, I think it was the provider case, talked about payments made for a happy and contented workforce, which is quite nice. And the Spur employees were both happy and contented because they got the free shares that increased in value. So Spur claimed a deduction in respect of that amount and spread it over time in terms of Section 23, capital H, which we can come to. And SARS took issue with the deduction in relation to it.
Can I just interrupt? Say, is it fair? My impression is that a lot of companies have share incentive schemes, broadly speaking, along these lines. Obviously not in the detail, but broadly speaking, and that there have been binding private rulings given by SARS saying that their contributions to the trust are deductible under Section 11A. Is that correct?
I've actually written it down. It's ruling 354, if anyone's interested. I won't say it was top of my head. And that's one of a few rulings that have been granted, where SARS, basically the Advanced Tax Ruling Unit, said that the contribution in similar circumstances was deductible. That ruling was given in 2020, so it's a very recent ruling and still applicable, obviously only to the parties that applied for it. But that was very much on point. And so, as you say, Trevor, and I think part of the reason that this case has made a lot of news is the fact that there are a lot of these share incentive schemes floating around, set up on sort of vaguely similar basis. They're all slightly different, and we can come to some of those distinctions in a minute. But that's the reason it's caused such a stir. And Trevor, you'll know this. I love the phrasing. Milton Seligson sort of introduced me to it. He said, it's not a case of case law changing the law, because the common law is discovered. I love that phrase. You discover the common law. So in a sense, it becomes retrospective, not in the legal sense. The SCA is just saying this has always been our law, and they're just discovering it as we go along. But I think that's what's caused some of the fright in the market as well, is that in a sense, even if you set up your share incentive scheme some years ago, you're still, subject to this judgment.
Yeah. And I see the solar glass case got a mention, albeit very brief, just without any mention of the fact that Section 23G was amended after that.
Yeah, that's true. That was on the trade requirement.
Yeah.
The main focus was on the production of income issue, and the court held that there wasn't a sufficiently close causal link in relation to the contribution, and that was largely driven by the fact that the employees came in at the NUCO level, as opposed to being beneficiaries of the trust, which is the more kind of usual construct, that the beneficiaries are quite often beneficiaries of the trust, or the employees are beneficiaries of the trust, as opposed to at a level down, in this case at the NUCO level. Maybe just to read that little bit of the judgment. I don't have it in front of me, but basically said that there wasn't a sufficiently close causal link, and quoted PE Tramways, and said that what happened here, and what the court found, and it's factually the case, but it found it was important in terms of its interpretation of the law, is that Spur Holdco was the capital and income beneficiary of the trust. And if you recall, on redemption of the preference shares, the Spur Holdco shares went up to the trust. And so the court said, well, Spur Holdco was the capital, income and capital beneficiary of the trust, and it ended up getting rights to its own shares. And, where were the employees in all of this? They weren't involved in the trust arrangement. So that sort of that indirect link in terms of which the employees came in for shares at NUCO seemed to be quite fundamental in terms of affecting the court's thinking on this production of income point.
Yeah, you can almost imagine the judges thinking to themselves, this is actually a benefit for the holding company, but it's been dressed up as something that's a benefit for the employees. They didn't say that, but one suspects that might have played a role.
I think the other sort of important sort of distinction that one can look at in terms of other arrangements is that this is essentially a funded scheme. So you get share incentive schemes where the capital contribution, or the contribution that's made, which is deductible by the company making it, is used to buy shares, and all of those shares eventually end up in the hands of the employees. Yeah. Whereas here, the 48 million rand essentially provided preference share funding to NUCO. NUCO bought the Holdco shares, and it was only the upside that's in value that accrued ultimately to the beneficiaries. It wasn't the whole 48 million rands worth of shares, it was only the increase in value. So it was essentially a funded scheme. Yeah. And sometimes these are set up with real funding like this, and sometimes there's sort of a national vendor funding arrangement in place where the employees only get the upside. And I think that can be distinguished from a situation where the employees get all of the shares that are acquired with the contribution.
Yeah, so perhaps part of the message is all is not lost. Don't
so,
abandon hope.
And I think a lot of clients are sort of scrambling around and sort of looking at whether the suppliers, because obviously it's fundamental, as we said, it applies to all share schemes, whether they've been entered into, whether they are still going to be entered into or have already been entered into. And, you know, you need to, if it applies and you claimed a deduction, that's obviously a problem. So you need to see if the case does apply or if you can distinguish it on the facts. So I think that's what a lot of people are busy doing right now. There were also quite a few, there were some interesting points around prescription, Trevor, as well. Noticed that.
Yes, because the court then, I mean, it was clear that the Spur had given wrong answers to some of the questions asked on the tax return. And the question really was, I mean, so that was a clear non-disclosure or misrepresentation. And I don't think the court actually said this, but we know that it is the case that a misrepresentation can be an innocent misrepresentation. It doesn't have to be deliberate. But the question then is whether that misrepresentation caused the fact that SARS didn't pick up what it eventually did pick up during an audit, but it didn't do so during the 3-year prescription period. And I think that raises a few questions. And it certainly makes interesting reading. I mean, you know, this is fresh in my mind in both a positive and a negative sense. Fresh in the sense that I've only just read it, so I haven't had time to forget it yet. But in the opposite sense, it's not yet entrenched in my mind. But I think what the judge said and what the SARS witness said was that Mr. Singh said that certain of the questions, depending on the answers to those questions, they will trigger an audit. And so that where the taxpayer has given the wrong answer, then a trigger that might have been there would perhaps not be there. And it was kind of on that basis that they said that there was a causal link between the wrong answers and the fact that this wasn't picked up within the 3-year period. But there are sort of lingering questions around that, I think.
I think, as you say, it's just not helpful when you submit your tax return. In this case, it was 2005, Spur submitted their tax return. And one of the questions was, did you claim a deduction to which section 23 capital H applied? And they answered no, which was incorrect because 23 capital H did apply. We'll come into that in a minute. And then also, did you make a contribution to a trust? No. Did you form a trust? No. Yeah. And I think the answers to all 3 of those should have been yes. And they pointed to the fact that there was a junior employee who kind of made a mistake, but that's not really the test. The test is whether there was non-disclosure of material facts. And then, Trevor, as you said, the causal link between that non-disclosure and the SARS assessor not picking up what they would otherwise have picked up if you had fully disclosed and correctly disclosed.
Yeah.
So,
and there's also the fact that I think it was in the Transvaal Sacred Corporatie case where the court held that although something had not been properly rendered in an income tax return, the financial statements that accompanied that return did make what SARS needed to know perfectly clear so that it had been disclosed. And the court sort of disavowed that approach in the Spur case. You know, I think they said that what the computer captures is only what's in the return. It doesn't capture what's in the financial statements. So that somehow doesn't count. But then that raises the question, well, then why do you have to submit your financial statements? What's the point of it? You know? So I think that it leaves some unanswered questions.
And I think prescription is really relevant because SARS tends to ignore prescription, you know, when they're doing audits and things. I very rarely see SARS say, you know what, I can only go back 3 years, so I'm only going to ask for information for 3 years. I find the more normal approach is to go back as far as they want. And then if you raise prescription and say, well, we need to establish where the prescription applies, and, you know, maybe that's right. But then as you go along the process, when you get your audits, they typically go back way longer than 3 years. And prescription is generally not applied. And it's often on the basis of this argument that there is non-disclosure of material facts and the causal link.
Yeah.
So I think it's really important, Trevor. And, as you say, for taxpayers, it's really hard to know what to disclose. At least at a minimum, you must complete your tax return completely and accurately, I think.
Yeah.
But it's a question of whether that's enough and whether you need to tell SARS more than is in the tax return. Intuitively, you think no, because the tax return is the tax return. But, there's certainly a school of thought that the tax return and the information required by it is not sufficient. And if there's something else SARS needs to know, you need to tell them about it. And that's very hard in the world of e-filing. Trevor, you'll remember years ago, we used to submit lots of annexures, as a manual process, and you used to, whatever you needed to tell SARS, you just stick it into an annexure. And you can still do that and upload annexures, but it's a lot more difficult and cumbersome, and e-filing doesn't really cater for that. It's not really intended for annexures. But in the old days, hesitate to say good old days, but the old days, you would just bang in as much information as you wanted. And that I think that sort of helped with prescription. I don't think that prescription law is caught up with the e-filing world.
Yes, I remember an old case. When I say old, going back to the 1980s.
That is old.
Yeah, not as old as me, but because I remember it. But it was a situation where the evidence was at that time there was a particular. So it's long before e-filing. There was a system whereby only in the case of companies, the SARS would just accept whatever was in the company tax return and issue an assessment accordingly, just in order to collect, so that tax then became payable. But then they would go through it subsequently. And the case had something to do with, I think there was a 3-year period for prescription, but a 2-year period for certain decisions, certain SARS. It was since changed to 3 years each. And the matter went to court. It was, if I remember correctly, a KwaZulu-Natal decision. And the judge said that, an assessment is a determination. And where the computer simply accepts what is in the tax return, that's not a determination. So it wasn't actually an assessment previously. So the SARS was within its rights to assess for the first time after a period of 3 years. And that just seems crazy to me, because that then means that there was, if it wasn't an assessment, then how could the taxpayer have been liable under that piece of paper which called itself an assessment? Whereas now with the Tax Administration Act, I think the Act contemplates that an original assessment will simply be according to what the taxpayer has rendered and on the basis of e-filing. And that is an original assessment, and it's authorized by the legislation. But both the Tax Administration Act, and there's still a definition of assessment in the Income Tax Act, they both use the word determination. If you go back to some of the old cases like Irvin and Johnson, where Judge Watermeyer said, an assessment is not the piece of paper, it's not the notice of assessment, it's the determination. And he points out that that's a mental act, but it only has force once it's reduced to writing and quantified in amounts and figures. So it seems, but maybe the determination in today's world is that SARS or the commissioner or the Act, or whoever it is, and whatever it is, authorizes the issuing of an assessment on that basis. So somebody has determined that whatever the taxpayer submits will be the original assessment. But as I say, I do think certain questions are posed. And also, perhaps you want to comment on this, but that comment of the judge at the end that the court doesn't wish to come to the assistance of taxpayers where they've filled in a return wrongly. I don't think that's particularly helpful.
And I think it's just, as we said, it's you can see how the judge's sympathy is not going to be with you if you've incorrectly submitted your return. So it just is not a helpful starting point, as you say, even if it shouldn't be sort of legally relevant. And it's such a pity in a way, because the prescription would have applied, as we said. The scheme was set up in 2004. It was closed down in 2009. And so long after the deduction was claimed, which was spread over the period from 2004 up to 2009, it would have been a complete defense. Prescription would have been a complete defense, I think. So, it's you need to double check the timing, but it's you often get the case where you can use prescription as a complete defense, and if you haven't disclosed properly and there is that causal link, then you can't, and SARS goes back as long as they want. And the other, Trevor, you'll know much better than me, but memories fade as well. So when you're leading evidence about something that happened in 2004,
yeah, exactly,
and the onus being on the taxpayer, that's quite tricky. It's 17 years ago. So
the one little chink of light in the judgment, I found the judge said that it was trite, and that it's accepted that it's for SARS to discharge the burden of proof as far as displacing the taxpayer's immunity after 3 years is concerned. So in other words, SARS has to show that that the causal link between in this case, the misrepresentation, let's assume it was an innocent misrepresentation, SARS has to show that caused the non-assessment. And another thing that just occurred to me now is the Tax Administration Act only came into force in 1st of October 2012, if I remember correctly. All of these events preceded that, but haven't considered whether it's appropriate. I think with procedural stuff, you can take later legislation into account.
And there were some transition processes, and they sort of synthesized, if you like, the Tax Administration Act with the Income Tax Act.
But I think there was also a provision which said that you, there's a provision which said the provisions of the Tax Administration Act apply in respect of the past. But then there was a reserving clause which said that the taxpayer was not to be prejudiced by that. If the taxpayer had a right to something, then that survived.
Another interesting point that I didn't mention, I should have mentioned earlier, is that both the tax court and the full bench found in favor of the taxpayer.
Yeah.
So it was the SCA went against 2 prior judgments, and quite unusual, because that's not unusual, but what's unusual is that you normally go tax court directly to SCA. In this case, that wasn't the situation. They went to the full bench, and the full bench found for the taxpayer as well. So it was only the SCA that reversed that. So it would have come as a bit of a sort of a shock, as I say, to the taxpayer. It's already been 2 rounds and won 2 rounds, and so.
I've had that experience myself, not as a taxpayer, but as a legal representative. It's not very nice.
The question is where to from here? I mean, I've heard it's market talk off to constitutional court, but I mean, it's quite difficult with the tax court, the tax case, to go to the constitutional court, and some have tried and failed that route. So, that's that I'm not cited on, but that's that's the only remedy left to the taxpayer if they want to pursue any remedies.
In fact, the one case that did go to the Constitutional Court was Big G.
Exactly.
20cc, and that was a franchisee of the Spur, funnily enough. So maybe they should take heart from that.
That's true.
Then there was the Clicks case.
Yeah.
And then I heard recently the Console Glass. They applied for leave, and the leave was refused. So it is difficult. Yeah.
Mm-hmm.
I think one has to be able to show some sort of misdirection by the court,
So that's going to come back to section 23A. So that's basically the spreading provision. So when you make a payment and the payment relates to goods or services that will be delivered in a future year of assessment, or to any other benefit that will be enjoyed in a future year of assessment, then you need to spread the deduction over the period that the benefit is obtained. In this case, that would be the relevant provision: the benefit is obtained. And so the deduction was spread by Spur Corporation over the 5-year period, the period from when the employees took up the shares in UCO and when those vested. So there was a spreading in terms of the 23 capital H provision, as is quite often the case in respect of share incentive arrangements, because the benefit that the company gets is often not immediate. It gets a happy and contented workforce over the period that they are incentivized. So there was a spreading over that period.
You said it would be a restrictive equity instrument for 8C purposes. I suppose that would provide the period.
Yeah, exactly. That's what provided the period. And I think just another point, Trevor, what I think about it is that, the result of this is one-sided tax, if you think about it, because Spur has made a payment which is now not deductible, so no deduction for Spur. And the individuals have been fully taxed on the upside that they got in terms of their restricted equity instruments, because when they vested, that of course is included in their income. Yeah. So you get sort of one-sided tax in the hands of the employees with no deduction. Whereas generally, if you pay an employee a cash amount, whether it's a bonus or a salary, company gets the deduction, employee is taxed on it. You get that sort of tax symmetrical result. This is a tax asymmetrical result. So, I think that to me is not really relevant because there's no equity in tax, as we know. But sometimes, SARS makes a point of that and says the tax asymmetry should be avoided. Well, this is a tax asymmetry, and it has not been avoided.
And it just occurs to me that that's a sort of argument that might hold sway in the Constitutional Court, which is more concerned with equity. Yeah.
Okay.
As we said, thought of that point. Yeah.
The 48 million rand deducted by Spur is not the same amount that was taxed in the hands of the employees, but still there's a tax asymmetry here. And that's partly why those binding private rulings are often granted, because, to avoid that kind of tax asymmetrical result and to say, let's just act as if Spur had paid a bonus to the employees. Deduction on the one side, tax on the other side. That's kind of a fair result, but that's not what's ended up being the case. Yeah.
Was that 48 million actually received by the holding company?
That was ultimately, the value of that was received by the holding company ultimately. So, as I said, it was the upside.
If it had come back to the operating company, they might have had a recoupment, which would have perhaps made more sense.
So an interesting judgment, and so it caused a bit of a stir.
Okay, now for the thousands upon thousands of people who are watching this this discussion, seriously, for the few people who are watching it,
I thought it was millions.
Well, whatever. What should people do? If they're party to participants in a share incentive scheme, or the companies, I suppose they need to take advice. It should certainly be worthwhile doing so, and just see what their position is in the light of this judgment. That's no doubt why it's causing a stir.
I think that's right. So I think in respect of any share incentive schemes that have been set up already, the companies need to see if they claimed a deduction, whether they shouldn't have in the light of this judgment. And for companies that are looking to set up a share incentive schemes, I think they need to pay very close attention to this judgment. And to me, an important sort of takeaway point is to get your employees to be beneficiaries of, or contract with, or be linked to your share incentive vehicle, which is often a trust. That would have, it looks like from the court's judgment, would have been a complete solve in respect of this case. So don't incentivize them at a different level, I think, is a big takeaway from me from this case. And fortunately, that is often how these things are set up.
Yeah, that would have provided the direct link between the 48 million contribution to the trust and the benefit to the employees, and thereby the benefit to the company itself.
Exactly, 100%. Yeah. So that's my big takeaway, and but we'll see how it unfolds in the coming sort of weeks and months.
Yeah. Well,
as you said, that was a very part of the press.
Yeah, and it's an interesting topic, and we were going to talk about something else, but
leave that for next time.
Supreme Court of Appeal hijacked this discussion.
Thanks, Trevor. Good chatting as always.
Yeah, very nice to chat, and I mean, this just shows that one's got to keep abreast of what's going on, and the apple cart can always. The fiscal apple cart can always be upset at any moment.
We practice in an interesting area, as we know.
Yeah, indeed. Yeah.
Interesting and dynamic. Yeah.
Yeah.
Thanks, Trevor. We'll speak soon.
Okay, great. Yeah, thank you very much. Cheers.
Cheers.
Bye-bye.
Bye.